Good
participants.
evening. The introduction indicated that we were going to talk about slavery or slave issue cases during the Civil War. Actually, we're going to talk about the freedom lawsuits that occurred prior to the Civil War. And what I'd like to do is start out with some of the laws at the beginning of our country and then right before the Civil War. Before our country even technically got started, we had the Northwest Territory, and then, of course, our United States Constitution, which looks like I misspelled there. Sorry about that. And then at the other end of the bookends, we have our Supreme Court case of Dred Scott, Missouri slave that sued for his freedom. And that was a case that probably was somewhat of a trigger for the Civil War, not necessarily the only thing that would cause us to go to war over each other. But nevertheless, those are the two situations at the end of the study of law on these freedom cases. So, first of all, the Northwest Territory. The,
Here, you want to say it?
This was part of the peace treaty of 1783 when the end of the Revolutionary War with Great Britain occurred. As part of that peace treaty, and this, I think we probably all know where the Northwest Territory is. This might be a little better map to show you what part of the country we're talking about. But nevertheless, as part of the peace treaty of Paris in 1783, Great Britain gave the United States this western region that was referred to as the Northwest Territory. Now, before the Constitution was even ratified, Congress at the time passed the Land Ordinance of 1784 to regulate the development of this area. Now, there were several conflicting claims on the existence of who owned this property. Most of the East Coast states would extend their boundaries westward, trying to claim more land west of their boundaries. And Massachusetts and Connecticut and New York claimed parts of this Ohio River Valley. So the federal Congress, even before the Constitution was created, set up a plan of development for these Western territories. The goal was to sell land to private citizens and to land development companies as a source of revenue of income for the new federal government. But also, they put in the ordinance that slavery would be prohibited. And that's probably mostly due to the influence of the northern colonies. And then after the Constitution was ratified later in 1789, the first Congress reaffirmed this Northwest Ordinance along with the prohibition of slavery in this particular geographic area. So in combination with the Constitution, of course, there's a Constitutional Convention in 1787 from May to September. A lot of debates were going on, including the issue of slavery. Now, a constitution is intended to be the governing document of a country. There's usually a lot of diverse interests, a lot of different viewpoints. So it's kind of a compromise document in the first place. And slavery was contentious, but there was really no effort to prohibit it in the Constitution. This was due mostly because the southern states were more involved in the debates than they were at the time of the Northwest Territory. So the focus was more on compromise in order to form the nation, as opposed to trying to prohibit slavery. So the Constitution did address slavery without actually mentioning the word slavery in the Constitution. A slave was determined to be counted as a 3/5 of a person, basically. And there was a fugitive clause in there that said any runaway slave had to be returned back to the owner, even if that slave had run away to a northern state that had a prohibition against slavery. As part of the compromise, there was an agreement to end the slave trade. That is, ships could not bring in more slaves after the year of 1808. So uh, after the signing of the Constitution by the delegates in September of 1787, the Constitution required a ratification of the states. So what that meant is that the delegates had to go back to their home states and try to convince their local state legislature to pass this. And in the meantime, Alexander Hamilton and James Madison wanted to promote the approval of the Constitution. And the two of them, along with John Jay, wrote newspaper articles to try to convince the people that the Constitution was a good thing. And these articles became known as the Federalist Papers. Nothing really was mentioned too much about slavery in the Federalist Papers. Madison tried to do some explanation in the Federalist Paper number 54. And it seemed like Madison was very uncomfortable with even talking about slavery, but he explained that a slave at the time was really a mixed character of property and a person. So slaves were considered both property and persons. And if the purpose of government was to protect property and persons, then the issue of slavery would have to be resolved with a compromise amongst the different interests involved. So we have property that is subject to taxation. We have persons who can vote and become in the representative part of Congress would be counted for determining the number of congressmen. So the compromise was this 3/5 population clause that counted the slave as a partial person. And Madison basically explained this as he says, quote, "It's a compromising expedient necessary to pass a constitution acceptable to all states." The concern was that the southern states would consider it unfair to include slaves in calculating taxes, but not for the number of representatives apportioned to the states. So the delegates to the Constitutional Convention did not want to disrupt the proceedings. They wanted to form the new nation, and that was really the issue with regard to slavery. Let's just let it go for a while, and that's really what happened. They decided that slaves would be left out basically on a limb for future generations to decide the issue. And this picture here kind of gives a little indication that the delegate, the colonial person in the middle, was out on the limb with the slaves, but they're still left out on the limb after the convention, after the Constitutional Convention. Now, looking at the other extreme of our bookends with regard to the chronological history is the Dred Scott case. And that case came about from a freedom lawsuit here in Missouri. Dred Scott filed a lawsuit to seek freedom. And his owner was in the military, a physician who was assigned to move from St. Louis to Illinois to serve in the military. And then later on, he served in at a military site up in Wisconsin, which was part of the Northwest Territory. So you had a new state of Illinois that said, we do not allow for slavery. We have the location, Wisconsin was not a state at the time, but the part of the Northwest Territory that prohibited slavery. So Dred Scott's argument was, I was on free territory. That made me a slave. I'm entitled to my freedom. However, in 1857, when the case was decided at the United States Supreme Court, the justices determined, no, Dred Scott, you're not a free person. In fact, the chief judge, Tawney, went way beyond what the facts and the law required him to do, and made a court ruling that basically said blacks are not even citizens, and therefore they cannot even file lawsuits in federal court. Slaves are deemed to be property. Congress lacks the power to prohibit slavery, and anywhere that there's an attempt to limit slavery would violate the constitutional due process. So, with the Dred Scott case as basically ending the idea of having freedom lawsuits for slaves, let's look at Missouri. Now, the basis in law for Missouri, of course, included the Northwest Ordinance of 1787, as well as the United States Constitution. So any lawsuit in Missouri would have to look at those two bodies of law. Also, our body of law includes the common law of England. And in fact, our state statute identifies the law of England from 1607 as being part of our law. Common law being that law is decided by judges. So when we became a state, we adopted the common law of England. And then as time goes along, we create our own statutes which would take precedence over common law. Then because Missouri was part of the Louisiana Purchase, which was at one time owned by France and Spain, there were laws there that had to be respected as well. And in fact, before we became a state, the Louisiana Territory had some laws written down in 1807 that applied to slavery as well. Then, because a lot of these freedom lawsuits dealt with individuals from St. Louis crossing the river into Illinois, we had to deal with the Illinois Constitution, in which slavery was not allowed as well. Then, when Missouri became a state, it was admitted as a slave state, and the 1820 Compromise was part of our body of laws as well. And then, when we became a state, 1824, we had a Missouri statute that addressed the freedom lawsuits. And that Missouri, that Missouri statute was, in my opinion, very generous to the slaves in seeking their freedom. Now, obviously, there's a lot of consequences to filing a lawsuit against a person, especially a slave against a master. But the statute did provide that the slave would be assigned a lawyer. Obviously, most slaves didn't have money to hire their own legal counsel. And so the statute said, well, we'll provide the lawyer so that the slave can pursue their freedom, or at least present their case and let the judge decide whether or not they should be free. A lot of times there were a lot of volunteer lawyers along the way that were in favor of abolition of slavery. But nevertheless, the law allowed for a lawyer to be assigned. The slave was given the liberty to meet with the lawyer and come to court. So the master had to allow the slave to attend to see the lawyer and to come to court. And the law said that the master, the owner, could not take the slave out of the state, out of the jurisdiction of the court. And then the language here says the slave shall not be subject to any severity. No punishment for filing a lawsuit, basically. But there were a lot of cases where the master reacted adversely with beatings and more work and created a lot of suffering to the slave. However, the statute went on to say that if there was the restraint or the violation of allowing the slave to see his lawyer or any beatings, anything like that, that the judge could bring the slave before the court and require the master to either file a bond, a dollar amount that said, that there would be no more beatings, no more removal from the state's court's jurisdiction. Or if the judge felt that bonding was not sufficient enough, the judge could transfer the slave to the local sheriff, and basically the slave would be hired out for a fee as a servant to a private party who would pay a fee for having the slave. A lot of times, the sheriff would place the slave in the jail for his nighttime accommodations, and then send him out to work for a fee that the employer would pay. And then the sheriff was required to keep the money and save it for the court to determine who the winner was in the case to receive the money. So that was kind of the statutory framework for these freedom lawsuits, that a slave could freely file a petition and have a chance to prove their case. So let's look at some of the cases along the way. In 1824, one of the first cases was this Winnie versus Whitesides. And Winnie was in 1797, had been living in Carolina. The case wasn't clear whether it was North or South Carolina, but nevertheless, in a slave state. The the master, moved to Illinois, stayed in Illinois for a while, creating residency there, and then in 1801 moved into Missouri. So you have a slave state of Carolina moving into a free state of Illinois, and then into Missouri, a slave state. So what the court did was basically say that Illinois at the time, it wasn't a state, so it didn't have its own constitution, but it was part of the Northwest Territory, and the Northwest Territory's ordinance clearly said that slavery was forbidden. The court ruled that if the owner had established the residency in the Northwest Territory, in a free territory, then the individual would be a free person. And the ruling was that the personal rights obtained by the law of the particular place, that is in Illinois, that continued to be part of that person's character, wherever he may go, even after living and moving into a slave state. So anytime a master takes their slave into a free territory, the master basically is declaring his slave to be free. And that freedom remains with the person. Slavery does not reattach. You can't revert back to a slave after you've been declared a free person. So the Missouri Supreme Court in 1824 said that once you're free in a free territory, you're free forever. Once free, always free is a phrase that was developed. Now, the cases as they go along have some distinctions made. This next case from 1828, LaGrange Isadora versus Chateau, was a case where the owner had a flatboat, I believe, and was coming up the river and unloaded cargo on the Illinois side and had the slave assist. So apparently the slave actually probably stepped on the shoreline. So when they came back to Missouri, the slave sued, saying, I stood on free territory. Illinois was free territory. And but he lost the lawsuit. The slave lost the lawsuit because the court at that time ruled that you were just merely passing through. You weren't staying long enough to be considered having the benefit of freedom. And they used, again, the ordinance of 1787, the Northwest Ordinance, was not intended to be a penalty, but it was also a law that protected any inhabitants of the territory. So it was a case in favor of the master because the Northwest Territory law protected the master just as equally as the slave. And because the slave didn't stay in the territory, didn't establish any residency or didn't really stay, just traveling through, the court made that distinction. So it looked, 4 years after the Winnie case, in which it says once free, always free, the court decided, well, there's got to be a time limit on the distinction between passing through and an intent to remain in the free territory or establishing a residency. Now, another case in 1829 makes a distinction too as to what the Northwest Ordinance of 1787 meant. So Theo Tessie was born in Illinois in 1782, coming to Missouri as a child, basically sued saying, well, I was born in a free territory. Once you're free, you should always be free. Well, the court ruled, well, when you were born, when you were in Illinois, the Northwest Ordinance wasn't around. It was a law that was created in 1785, right? 1787, years after your birth. So you can't take advantage of a law that didn't exist when you were born or when you were claiming your freedom. So this particular lawsuit said that again, it's a timing issue with regard to when freedom attaches. Vincent versus Duncan, the slave owner brought his slave to Illinois to provide labor. Apparently, rented the slave out to somebody in Illinois. The master remained a resident in Kentucky and then moved to St. Louis and then brought the slave from Illinois into St. Louis. The slave sued, Vincent sued for freedom because he had worked in Illinois. So the court ruled, well, there was an intent by the master to allow the slave to reside in a state that was a free state. Therefore, the slave is free. So Vincent earned his freedom in this lawsuit because he actually stayed and worked in Illinois much longer than the gentleman that just worked off the boat off the Mississippi River. So there's, again, a timing distinction there. How long do you stay in the state, the free state? Another distinction, this 1834 case, Nat versus Ruddle, he actually escaped from his master and ran off into Illinois. Apparently, he was brought back to Missouri and sued for his freedom because he was in the state of Illinois, a free state. But the court ruled that you actually have to have, or the court has to look at the intent and the conduct of the master. And a slave who ran away without knowledge and consent of the master was not entitled to his freedom because he was basically doing a bad act. His unilateral action to be free doesn't count as the sole factor in determining freedom. We have to look at the master's conduct, the master's intent, to determine that the slave actually resided or intended to be in a free state. So looking at the master, the actions and the intent of the master became part of case law. Now, another case, this case, its distinction is based upon the fact that Illinois became a free state with its own constitution. So this was a case where Melvin was traveling with his master back and forth between St. Louis and St. Clair County, Illinois, to harvest crops. So he was working in Illinois, probably on a daily basis, back and forth. And the court ruled that because Illinois had its own constitution that prohibited slavery, Missouri has to respect Illinois law. In fact, the United States Constitution provides for full faith and credit and privileges and immunities between the states. So basically, each state has to show some respect for the other state's laws. So freedom was granted because the Illinois Constitution basically told the Missouri court that you have to give full faith and credit to our laws in Illinois. The slave was present enough times or enough duration in Illinois to be to be made free. Now, he was just working there, going back and forth, so he was not a resident. So some cases tried to make the distinction that you have to show intent to reside there, but his master allowed him to work there, and because we had the Illinois Constitution, that case is distinguished between the other case we talked about earlier about just merely unloading a boat. And that was before Illinois had its own constitution. So again, a timing issue and a duration issue played a part in this lawsuit. Another case is Rachel versus Walker. And this is very similar to the Dred Scott case you'll see. Again, a U.S. Army officer went to the Wisconsin Territory, brought his slaves with him. The slave did nothing else than serve the officer, so the slave wasn't really getting outside the house and being part of the Wisconsin Territory. But the court ruled that you were still there in the free territory. The Northwest Ordinance applied, and the Army, made you go there, but the Army didn't make you take your slave with you. So that was the distinction. You introduced slavery into a place that prohibited it, and therefore your slave is made free. And some of these documents are available. This is a copy of the petition in the Rachel versus Walker case. The Secretary of State's office has some of these documents that you can access digitally, and Washington University has a freedom lawsuit archive as well. So sometimes it's hard to read the writing, but it's kind of neat to know that these cases actually survived, their documents did. So those are some of the highlights of cases. There's at least 300 different cases that exist in documents either at the Secretary of State's office or at Washington University. So I just gave you a quick summary of some of the cases. So there are other types of court cases too that didn't necessarily relate to a slave filing a petition for freedom. There's, of course, an owner can do offer freedom to the slaves as well. There were deeds of what they called manumission, where a owner would be able to sign a document like a real estate deed and say you are hereby free. But a lot of times those cases that the slave having a deed of manumission were contested. Either the family maybe would say that the document is a forgery, or dad didn't know what he's doing when he's signing that piece of paper. So there's some court cases about whether this deed of manumission, this freedom document, was really a valid document. Sometimes the slaves could even purchase their own freedom. But then again, that was disputed. Was that really a contract that could be enforced? Sometimes the owners were deceptive, taking the slaves' money and still not granting the freedom. A lot of times it seemed like family members would get involved and, again, say daddy didn't know what he's doing when he took the money for the slaves' freedom. And there's a lot of probate cases too. Since slaves were deemed to be property, you could put it in your will as to where your slaves would go or who would inherit the slave. And a lot of times some owners would say, upon my death, you are hereby granted freedom for your faithful service. And of course, a will has to have some formality to it. Obviously, you have to have capacity, you have to know what you're doing, and it has to be probated, approved in front of a probate judge. So a lot of times, sometimes these wills and testaments were disputed. A will contest, again, capacity issues possibly, or a disinherited child would want to contest it. Then there were some cases with regard to whether or not the Black person was truly a Black person. There was issues of how much blood does it take to be considered a slave, and if you were a slave but you could prove that you didn't have a certain percentage of black blood, you might be able to earn your freedom as well. And also with Native Americans, some Native Americans were held as slaves many years past. The Louisiana Purchase documents in the Spanish law and the French law prohibited Indian slavery. They wanted to maintain good relationships with the Indian tribes, and they prohibited the slavery. So if someone had Native American blood, they could uh, show the blood relationship and possibly gain their freedom. One of the Missouri statutes defined uh, the your ethnic background as black if you had one grandparent that was black, but it didn't say how whether that grandparent was 100% black or what percentage of black it was. So it's kind of an odd law actually. Some other states, like I think, like Louisiana, basically had a rule that said, one drop of blood makes you black if that happens. But Missouri was trying to make a little bit of a distinction, but it never was very clear. So the ultimate resolution to these freedom slave cases was unfortunately our Civil War, and of course, President Lincoln was probably the main leader with regard to gaining the final freedom for uh, our population, in leading to eventually to the 13th Amendment. But Lincoln tried to preserve the Union, and in his election, uh, the Southern states didn't really believe him. In fact, Lincoln criticized the Dred Scott case. He basically said that that's bad law, and the fear was, from the Southern states' perspective, that Lincoln would not follow the Supreme Court. In Lincoln's first inaugural address, he tried to address that issue by saying, the Supreme Court is indeed the final decision maker with regard to some of these constitutional issues. And he said that he would not end slavery where it existed. His focus was on preventing it from going to the territories, expansion of slavery. And but he also emphasized the fact that the preservation of the Union and the fact that any state is not lawfully allowed to succeed was his focus. Uh, there's a lot of literature on the evolution of Lincoln's views on slavery and what the Civil War is all about. But basically, I wanted to end tonight with the idea that it actually took a civil war to actually grant the full freedom that some of these lawsuits attempted to do. But the lawsuits obviously had different factual situations. Judges interpreted the law differently, again, it took a civil war for us to resolve this issue, sadly to say. So I conclude that way with any questions, comments, or further discussion.
Scott decision, or the Dred Scott case, so important?
Why is it so important?
Is it because it went to the Supreme Court? You had a
Yeah. So basically, in this presentation, it just put an end to freedom lawsuits. You couldn't file for freedom anymore because the court at the United States Supreme Court said blacks are not citizens worthy of having the ability to file a lawsuit in the first place. So that's the significance, is they're not deemed citizens. And then secondly, it overruled all the previous laws that prohibited slavery. It basically said the Northwest Territory doesn't exist with regard to prohibition of slavery. The Missouri Compromise, you can't put a line to where you have North and South or free states, slave states. It did away with the popular sovereignty of the Nebraska-Kansas Act of 1854. So it just did away with all the laws with regard to slavery, prohibiting slavery. Basically, slavery can exist. Taney basically said the Constitution favored slavery. It wasn't a compromise as to how to keep the country together in 1787. It was a document that clearly identified certain things that favored slavery. Of course, he favored slavery. I mean, he was biased. There's no doubt about it. But he saw the Constitution, and his reasoning is that the Constitution did favor slavery, and that he was bound as a judge to show favoritism towards slavery. And and there was arguments that he just didn't like the northern people, I guess. So
Well, there was something about it. Tony thought his decision would end it all.
well, that's right. I think that's what you're right. He was saying the Constitution favors slavery. We, the Supreme Court, make the final decision. Let's get over this issue. You can have your slaves. Yeah. Which all it did was embolden or anger the northern people to fight harder, is the bottom line. Yes.
I don't know whether they can hear me through that microphone or not. You may have to repeat my question.
Oh, okay. I'm sorry. Yeah, go ahead.
The Shoto family was a very powerful family, but
Yes.
there was a recent article in Missouri Historical Review about the family and the matriarch of it. You had two cases with Shoto involved with slaves. Were they the same person?
The same family, yes. The question was the Shoto family out of St. Louis was, I guess, a very wealthy and powerful family. And there were quite a few freedom lawsuits against the Shoto family. So the question was, are they the same family? And yes, that's true. And I think the Shotos, they had the money to fight any lawsuit. And I think in some of these cases, it's probably some of the local lawyers that maybe had some bad dealings with Shoto that the lawsuits got prolonged. It was a fight between the lawyers and the Shoto family as opposed to representing the best interests of the slave sometimes, I think. But yeah, if you had lots of money and wanted to preserve your slaves, like the Shoto family, you were involved in lawsuits.
Was there much concern for the children, slave children, as opposed to adults?
The question was there much concern for the children as opposed to the adult slaves? Well, I didn't see any cases that were just specifically filed on behalf of children. In the Dred Scott case, it did include Harriet, the wife, and I think there were 3 children. So it did intend to include the whole family. So I think if the parents were deemed to be free, the children would get the same. Well, it'd come from the mother's side. So you'd have to figure out that the free mother would have free children. But I don't remember any particular cases that said that this particular petitioner was a child. And typically you'd have to have a guardian or an adult to represent you anyway. So it might have been the name of the lawsuit might have been an adult's name. But yeah.
Mike Devaney, I believe, has a question on Zoom.
I was going to make a comment about the,
Mike, we can't hear you. Do you have your microphone on?
let's see. Oh, I'm sorry.
You are unmuted, but we can't hear you, and I think your microphone might be off.
It's on.
Huh?
There it is.
Can you hear me now?
To sign language.
Oh,
Still
what's
don't
wrong?
have you.
Unmute. I want to talk.
You know what? It might be us.
Oh.
Can you hear me now?
They could type that question.
It's up here.
Oh,
It
here.
is up there.
Testing.
There it is.
Oh, okay. There he goes.
Can you hear me now?
We got you now. Thank you.
Okay. I was going to say that up until the Louisiana Purchase, the uh, Louisiana Territory, that's the west of the Mississippi, slavery was a much more benign environment. In fact, in New Orleans, for example, and throughout that territory, slaves were allowed to work for their own gain for certain periods of time, and save that money and buy their own freedom. And so, and that actually, that Louisiana Territory, of course, went all the way up to the Canadian border,
Yeah.
Montreal. And this, again, the article that was just referred to, that Harold referred to, is a great article on the whole Shoto enterprise, where they managed to acquire the fur trade. And so anyway, I would recommend that to anyone interested in that whole process.
Very good.
I think Dave's got his hand up.
Dave does have his hand up. Dave, do you have a question? Actually, I think that's maybe the back of his tiger. I think it's part of his tiger.
Okay, right. Oh, it's between the legs. I figured. That's it.
Yeah, it did look like a hand. Does anyone else online have any questions?
I have one more, if I can interrupt one again. I was
Please.
curious. It would seem that the slaves that were there, that in the Juneteenth area of Texas, that were liberated almost 2 years after the I guess after the Emancipation Proclamation, they would have the strongest case if you know. Again, I don't know if there's any activity on their part or not, but
Well, yeah, the Emancipation Proclamation was really a military order, only applicable to the rebel states, which Texas was. So yes, they would have had their freedom basically as because of a military operation. But you raise a good question. If they would relocate to Missouri, which remained a slave state, would they have their freedom?
Yeah.
And that's a good question. Legally, I don't know well, yeah, I think during the war, if the war was still going on while they lived in Missouri, they would still be free. But once the war ended, they'd lose their status as contraband. I mean, I don't know that for sure, but that would, if the idea of their freedom was because of a military order, the military order should end at the end of the war, and they'd lose their freedom. But if Missouri was following once free, always free, and based on a military order, you could make a good argument that your freedom remained even when you relocated to Missouri. But yeah, I'm not sure how that would work out, to be honest with you.
Missouri was not, the Emancipation Proclamation did not
It
apply.
did not apply to it. Yeah, yeah. But well, so what you're saying is that if they moved to Missouri, they'd reattach their slavehood because there was no need for military operations that was evident in Texas. Well,
Good question.
yeah, that's a good question.
what about if they stayed in Texas? Could they have sued Texas for
Well,
holding them beyond the?
Well, yeah, I mean, Texas was in rebellion, so they're probably not going to honor the military order. But yeah, they could sue. I don't know if a state court in Texas would take the case.
Yeah.
But I would think that the Union soldiers would be able to rescue them. If you know if the Union soldiers were nearby, but I doubt during the war that a state court in Texas would have taken the case up.
Thank you.
During the war, I guess many Virginia slaveholders sent their slaves down to Louisiana. And then what would happen if the state of Louisiana, fell during the war? Did that automatically free up the slaves that were there?
So that well, after January 1st of 1863, the Virginia slaves were deemed to be free, and the Emancipation Proclamation applied in Louisiana, though I think there were some parishes in Louisiana and some counties in Tennessee that didn't apply to, much like Missouri. We always think of all the South being in rebellion, but I think there were parts of Tennessee and Louisiana that were not. But anyway, let's say they went to Louisiana, that was part of the Confederacy, they would still be deemed free militarily. At the end of the war, the military order would end, and then of course we had the 13th Amendment pretty soon thereafter. So they eventually would be free.
Huh. Interesting.
I'm not in. Were there some parts of Louisiana and Tennessee that were not part of the
Emancipation Proclamation.
yeah, they had their own special proclamation. Yeah,
There's an exception, where he writes,
yeah,
I think Lincoln writes, and then he says, except for Plaquemine Parish, some
yeah, he did, yeah.
that did not apply to.
So, yeah. Well, so the Virginia slaveholder should have brought stuff to Missouri then, just to preserve the slavehood.
Right.
Yeah, that's
The reason why I know this is that
uh-huh.
there is a very famous part of Louisiana called Lafourche, which means, I guess, the bend of the river. And I was familiar with a plantation in Virginia, also called Lafourche, which probably meant that maybe the slaves originated in Louisiana or brought to Virginia with the name of the area going on to the plantation. Lafourche is not a typical Virginia name,
No, yeah,
obviously. And then eventually I read that during the war, because these slaves would be considered contraband, the slave owners just moved them back to Louisiana. And that was a sort of a weird thing, I thought.
yeah.
Are there any other questions out there?
I might just say that John Marshall, before Taney, didn't go as far as Taney did,
No, right.
but he was a slaveholder.
Yeah.
And traded in slaves. And often would side with against slaves that were trying to get their freedom.
Yeah. At the Supreme Court level.
Yes.
Yeah, of course. Yeah.
Are there more questions?
Marshall did what? You were saying Marshall did what now?
Well, I said he was a slave owner, and Taney came on the court while he was Chief Justice.
Yeah, he was a young person at the time. So he probably, yeah, he would have met
And so
Marshall.
from time to time, they would get cases of slaves wanting their freedom or that they'd gone north or whatever. And he often voted, or most times voted against giving them their freedom.
Well, and the Constitution provided for the Fugitive Slave Act, where the northern states had to
Right.
bring the slaves back to their owners. So that would have been probably under the Constitution the proper decision. For the purpose of the online individuals, the comment was that Chief Justice John Marshall typically favored the slaves in cases brought to him, and the judge in Dred Scott, Taney, or sometimes called Taney, he was part of the court at the end of Marshall's term, I guess. So there was a lot of favoritism towards slavery at the Supreme Court level.
And we have a Taney County.
Is that? Oh, yeah. Is that from
It's
named after him? Huh? Oh, really? Okay.
Yeah.
Oh,
Any other questions? Okay, before we leave, I've asked Bill to give a little bit of a preview about what he's gonna talk about next month.
Hi, everyone. I'm going to be talking, finishing up my work on what Dr. Varney has done with U.S. Grant's memoirs, and we're going to be finishing up with that work. And the Grant Rosecrans feud began, most historians would say, around the Battle of Iuka, Mississippi. And so I've just recently had a personal tour of that battlefield. I know most folks would think there's not a whole lot to see there, but it's been built over a lot. But I'm going to be making a presentation on the Battle of Iuka, Mississippi, and how that ties in with the Rosecrans Grant. Some people call it a lifelong feud. So we'll be visiting that in May.
Thanks, Bill.
Very good.
Are there any more questions, comments whatsoever? Not hearing anything? One thing I would like to have people bring into the May meeting is programs. Need to get a list of programs for the next season. So get it together. On that. So if nothing else, come before the group, class dismissed.